Okay, very good. I have them. Where would you like to begin, Mr. Contreras?
The courts. I know you have them in order.
I just will go in the order I have them right now.
Yes, Your Honor.
Okay, very good. Okay, let's start with the motion to declare section 921.141 L, I believe, Florida statutes unconstitutional and to bar state's use of hearsay evidence at penalty phase proceedings. Right? Any?
Judge, I'm going to rely on the motion and the case law contained therein and have no further argument.
Okay. And Mr. Harmon?
Judge, we filed responses to all of Mr. Chance's motions and we'll rely upon our written response.
Okay. All right, I will deny the motion to declare statute 921.141, I believe that's L, unconstitutional, and I will also deny the request to bar the state's use of hearsay evidence. Hearsay evidence is admissible at a penalty phase proceeding, assuming that the defense is given a chance to rebut that evidence. So that motion will be denied. All right, next up, motion for findings of fact by the jury.
Yes, Your Honor, we would, Mr. Chance, we would rely on the argument and case law contained therein and have no further argument here today.
Okay. State?
Your Honor, we filed a written response. I'll rely upon the state's response.
Okay. And just for the record, this motion would, is asking that I say that the jury's got to find additional findings of fact other than what the jury instructions require them to do in a capital case. So I will deny the motion. All right, motion to declare 91.1416N unconstitutional.
Judge, we would rely on the motion, argument, and case law contained therein.
Okay, and this is the criminal gang member aggravator, correct?
Correct, Your Honor.
Okay, Mr. Harmon?
Judge, we filed a written response. We would rely upon that in the argument that the aggravator is constitutional, especially in light of the heavy amount of evidence of showing a nexus between the facts and the aggravator.
Okay, that motion will be denied. All right, motion to declare cold calculated and premeditated aggravator unconstitutional.
The same, Judge. We would rely on the motion and the case law therein.
State you rely upon your response.
Yes, Your Honor.
Okay, I will deny that motion. Motion to declare 921.1412 and 3 Florida statutes unconstitutional. Mitigation must outweigh aggravation.
The same, Your Honor. We rely on the motion, the argument, and the case law contained therein.
Okay, Mr. Harmon?
Your Honor, we'll rely upon our written response.
Okay. We're going to stick with what is required currently under the law for the jury, so I'm going to deny that motion. Motion to declare Florida's death penalty unconstitutional based on violations of Article 1, Section 4 of the Florida Constitution and the First and 14th Amendments to the United States Constitution. Mr. Contreras?
No further argument, Judge. We rely on the motion, the cases and statutes contained therein.
Okay. Mr. Harmon, you rely upon your response?
Yes, Your Honor.
I will deny that motion. Motion to declare 921.1417 Florida statute unconstitutional and for pretrial determination of admissibility of all victim impact evidence. As to the, let's see, unconstitutionality of victim impact evidence, any additional argument, Mr. Contreras?
The only thing additional I'd say is I know the court had a specific ruling as to when Mr. Hernandez was up here. I believe you said it to all defendants. So
Yeah.
other than
So, yes, so any victim impact evidence has got to be in written form, and the state has to provide that letter, that written form to you all at least 24 hours before any person would testify. And at this point, it's got to be an adult. And at this point, the state's not limited to the number of individuals. However, at some point they may be, so you can always renew an objection if you feel that there are too many individuals that they intend to call for victim impact.
Yes, sir. No further argument other than that. Judge.
Okay, so I will deny the motion as to the unconstitutionality of section 921.141 subsection 7, and I will grant the motion with regards to pretrial determination of admissibility of all victim impact evidence, in that the state's got to disclose what they intend to have read to the jury, and then if there's a dispute or a challenge, I'll hear it.
Yes, sir.
Okay.
Thank you.
So denied in part, granted in part. Defendant's motion to preclude imposition of capital punishment.
Judge, I'll just rely on the motion and the case law I cited in the motion.
At this point, well, any response, Mr. Harmon?
No, Your Honor, other than our written response.
Okay. So at this point, I read this as a wholesale motion to preclude imposition of capital punishment. So I'm going to deny the motion. However, you're not prevented in the future from, particularly assuming we get there at a Spencer hearing, any arguments that are available to you legally.
Yes, sir. Thank you.
But that motion will be denied. All right. Do you have any others?
I have one more.
Okay.
I believe objection to death qualification of the jury.
All right. I don't see that, but it may be here somewhere. And tell me what the motion is.
I should have it here, Your Honor. That's a
Oh,
long
wait,
one.
hold on.
If I could,
It was 14 on the list, if that helps.
Well, it was when everything was in line, but I took it all out. So now it's good luck. Okay. Good luck putting that. Okay. Oh, here I've got it. Good luck putting that genie back in the bottle. All right. Let me just take a look. Okay. State, any further response?
No, Your Honor, we filed a written responses. There were multiple grounds raised in the motion other than death qualification. We addressed each in our written response.
All right. The motion will be denied.
Your Honor, I believe that's the last one I filed.
All right. So moving on, Mr. Gathright, on behalf of Mr. Gathright. Okay. Do you have a particular preference as to order?
You can tell me.
Okay, all right. I'll just
Whatever you
go
have
ahead.
there, I'll go with you.
Okay, I'll just go in the order I currently have them. Okay. So, motion for victim impact statements to be read by a neutral party. State what's your response to that.
Is this the motion in the general procedure?
No, this would be Gathright, motion for victim impact statement to be read by a neutral party. I guess they don't want an actual,
I believe I filed a response.
yeah, you did.
And we object, obviously, to that.
I mean, family members can read their statements, correct? Under the law?
Yes.
Can and they do.
And Your Honor, we would just ask for the same ruling or indication from the court as you did earlier, as far as if there's any minors.
So same situation, any victim impact evidence, if there's going to be a written statement that's read, it has to be provided to defense at least 24 hours before the victim reads the statement. And at this point, it cannot be a minor unless we talk about it. And if there's any dispute, then I'll take a look at it and I will resolve the issue. So as to the specific request that the victim impact statements be read by a neutral party, I'm going to deny that motion. Motion to declare Florida Statute 921.1418 victim impact evidence unconstitutional.
Yes, Your Honor, we'd rely on our motion.
Okay, state you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. Motion to preclude any potential death penalty proceedings based on violations of the constitutional right to a grand jury indictment.
We would rely on our motion, Your Honor, indicating aggravating circumstances or elements of a capital homicide, which must be pled by the state attorney and unanimously found by a jury.
Okay, Mr. Harmon, you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. Motion to strike proposed aggravating factor number 1 from the state's notice.
And Your Honor, I think based on a conversation we had last week, we can withdraw that motion. My understanding is the state's solely relying on the facts of this case that would be
Right.
heard in guilt phase.
A contemporaneous conviction, not anything prior.
Right.
All right, so that motion is withdrawn. Next up, motion to declare section 921.1416C unconstitutional on its face and as applied. This is the risk of harm
Yes,
aggravator.
great risk of harm aggravator, finding it vague and overly broad, we rely on the memo in our motion.
Mr. Harmon, you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. And motion to bar imposition of death sentence on grounds that Florida's capital sentencing procedure is unconstitutional.
Yes, Your Honor, we have indicated in that motion that the procedure is currently unconstitutional, permitting a verdict of death on a non-unanimous vote of the jury, and would rely on the memo contained in our motion.
State, you rely upon your response.
Yes, Your Honor.
All right, that motion will be denied. Do you have any others?
We had, it looks like, motion to declare 921-1416I unconstitutional. Let's see, and that's for CCP.
Okay,
You see
and
that?
I've been saying I, is it I or one? I don't know.
It's I.
Okay.
And we'd rely on our motion.
Okay.
If you have it, if you have it.
No, but if I mean, the motion is filed is to declare the CCP aggravator unconstitutional.
Correct.
Okay, that motion will be denied.
Let me just double check. We did have a few motions in limine. I think we can agree on most of them, but
You
just,
covered the victim impact.
we did.
Yeah.
Both were denied.
There's a motion to limit as to general procedures, I believe.
Yes. Oh, and I'm sorry, Your Honor, there is one more we filed the motion to strike the aggravator that was withdrawn, but we do have a motion to declare 921-1416B, the prior capital or violent felony, the constitutionality of that. And we rely on that motion if you have it. That one was filed. Some of these were filed at different times, which would be, that one was filed early January. The state did file a response to that as well.
Okay, do you rely upon your response?
Yes, Your Honor.
Okay, that motion will be denied.
I think that was it for the constitutional and those motions. We do have a motion in limine for general procedures.
Okay, what does it state?
The first one, I believe the state didn't have any objection. Section A of that motion was reference to non-statutory mitigating circumstances and use of words such as catch-all.
Yeah, we have no objection to that.
Okay, granted.
The next one was section B, the presence of media, family members, and uniformed officers and shackling of the defendant.
Okay,
I know this, go ahead.
No, it's okay. Your Honor, I spoke to counsel about this last week. We agreed, obviously, to any kind of shackling in front of the jury during those days. It's my recollection from Show, and I believe Richie possibly, that during penalty days, we maintained that. So the shackling is outside, it's covered up. for the jury.
yes.
Okay. As far as the other matters in that ground, we would defer to the court as far as the media.
Okay. And tell me, I feel like I've seen the motion, but I can't find it right now on my desk. So,
Your Honor, essentially, we are asking that the court instruct the members of the media to not interview witnesses, family members, courtroom personnel, people involved in a place in the courthouse that could be subject to the jurors observing, seeing.
okay,
I believe there's also a ground about use of cameras in the courtroom. If I'm just kind of looking at this from last week, there's an administrative order that deals with that. as far
right.
as-
There's only one camera that's permitted in the courtroom and it's got to be out of the way. And I do have a whole discussion with the jurors that they understand that their faces will not be shown, their identities will not be disclosed. So, yes, the motion will be granted and that the media knows and they've got to follow a certain procedure established by the courts. And I assume they will.
Perfect. The next section, we were asking C, names and addresses of potential jurors summoned to try the case and do individual questionnaires. You know, I don't believe that's Your Honor's practice, but we were seeking to do individual questionnaires for the jurors.
Okay, that will be denied. And then as far as the names and addresses, we get those the day the jury is pulled. So, and I think I told you all we're going to do 3 days of 150 back to back. So you'll get the 150 on the Wednesday, the next 150 on Thursday, the next 150 on Friday, the morning of.
Okay.
Okay. So you'll get them, but not before that.
Not now,
So I guess it's granted, but you'll get it the day of.
And we were also asking for individual and sequestered voir dire. My understanding is that the court does the individual or smaller groups as to hardship or media exposure.
Yeah, so individual voir dire will be done on anybody that thinks they know anything about this case. With regards to hardship, that will be done as a group for those that are claiming a hardship. And then on death penalty voir dire, that will be done again in small groups. That's not my traditional practice, but because of just the number of people that will be coming through for jury selection, I am going to break it down, the death penalty qualification questions into smaller groups. So probably the 30 to 40 range, we'll see whatever we think we can get through in a day. So, And I think I did mention this before, that normally I have a whole speech that I do before phase 2, which is death qualification. And I know the state has Mr. Harmon has a speech that I've seen him do before he begins. And normally I give the speech when we actually move on to phase 2. But in this case, what I'm going to do is I'm going to give my speech first thing Wednesday, Thursday, and Friday to the group of 150 as a whole, just because it is can be time consuming. And by the time I get done talking, by the time Mr. Harmon gets done talking, and then if the defendants wish to make a statement regarding penalty phase questions, it's, we're now into an hour and a half and we haven't even started talking to any of the jurors. So my plan is that Wednesday, Thursday, and Friday, the first week of picking the jury, I will give my speech to everyone there, but I will remind them that we're not going to be asking them any questions related to the death penalty in phase 1. And then if those that come back to go into phase 2, which are the death penalty questions, I will then just give them a brief reminder of what I said to them. And then I'll give Mr. Harmon a chance and the defense counsel a chance to give a brief reminder before we actually begin the questioning of the jurors.
Okay.
So if you all want to make a succinct speech regarding death penalty voir dire, you're welcome to do so. Okay. But you'll do it Wednesday, Thursday, Friday morning.
Once
of
we
the
pare
group.
down a little bit.
Well, you do it initially to the whole group.
Okay.
And then those that make it to phase 2, like I said, we'll do just a quick reminder of the points that were made when they first came in, but we're not going to do another wholesale intro for each of those small groups because it'll take forever. Okay.
Let's see, next was section E, objections being made contemporaneously with the occurrence of error to avoid procedural default. I don't know that did we discuss that, Scott? I don't remember if you have an agreement to that or not.
No, I don't believe we did.
Okay.
So is there any objection?
Judge, I would just, so when I just tried to ask counsel for clarification on contemporaneous objections. Objections made at the bench, objections made from counsel's table.
Just so there's not speaking objections from the
Right.
council table.
Granted,
Thank
I
you.
don't like speaking objections.
No, I don't think anybody does.
Some people like them, or at least some people like
That's
to
true.
make them. You
Yes.
do, but
Or some judges, when you say, can we approach, and they say no, and then you have to do it.
right.
And the last one, I believe, is section F, which was miscellaneous matters.
That's
Um,
what that's already said
And I
that
believe that the state is in agreement with that section.
judges don't
Correct.
allow.
I
it.
know this, of
She was
course,
talking about the last round about
in the past, being in front of your honor, when the state asked for the record to reflect that witnesses identified the defendant. The record will so reflect.
Right. That's all they ever say.
Perfect.
So I guess it's granted.
Oh my gosh, is her face oiled up or is it just me on my screen, y'all? Y'all let me know. Put a one in the chat if y'all see that oil. Good grief, she need a towel. Can't tell if she's sweating or what's going on. Good. Oh, wow. Maybe the camera hitting her in the wrong way. She needed powder.
With the understanding that that's what I will say.
Okay. And I believe that is it. We handled the state's motion to eliminate. Is that all you have?
Yes.
Okay.
Okay.
That's all
all
on
right.
behalf of Mr. Gathright. Thank you. Your Honor.
Okay, thank you. Okay, and Mr. Davion Murphy. All right, you want to start off with defendant's motion to strike aggravating factor, section 921.1416N as unconstitutional, and that's the criminal gang member aggravator, correct?
Judge, you're talking about my motion to strike? I apologize.
Yes.
Okay, so my motion to strike the aggravating factor 921.141BN.
Oh, we're switching to a different, I was
Oh.
looking at 6N,
Okay.
but that's fine. We can start wherever you want to
No,
start.
I was going to start at the general procedures
Oh.
and work from there, but whatever Your Honor wants.
Okay, it really doesn't matter.
I think it's probably easier. Not that anything needs to be hard.
That's fine. So where do you want to start?
The motion in limine regarding general procedures, I
Okay.
spoke with the state. I think we're pretty much in agreement.
Yeah, the motion is very similar to Mr. Gafford's motion.
In that it appears the state agrees with paragraph A,
I do, the state does agree with that.
and that
Okay.
is in regarding the non-statutory mitigating circumstances. Paragraph B, if I recall, you left that up to the court's discretion, and that will be the presence of media, family members, and uniformed officers and shackling of the defendant.
I don't think we address family members as far as that goes. I don't think there's any limits to family members being in the courtroom. We always instruct them not to wear anything that's provocative to the jury, such as photographs or any kind of memorandum.
Wait a minute, they're gonna know. They're gonna know. Oh gosh, let me rewind it so we can see what the note is that he's trying to do. Oh wow. He said he putting up a note of SOS. Here we go. SOS. Wait a minute. Oh gosh, this is fun tea. He tried to tell her, he said he being recorded. He want to let her know.
Defendant.
I don't think we address family members as far as that goes. I don't think there's any limits to family members being in the courtroom. We always instruct them not to wear.
Hey, wait a minute. I gotta see what it say now. Oh, this is crazy. He must can't get a phone now. It said, drives me crazy. Marshana Williams drives me crazy, but she my bae, my wife, and I love I don't know what that say right there. Her. Oh, wait. I love her so much. Oh, he say Marshawn Williams drives me crazy. So I want to say, I don't know if that's serious, but she drives him crazy. But she, my bae, my wife, and I love her so much. Oh, he said he wants the world to know how sweet it is to be loved by, I guess, him. I mean, shoot, he ain't got no choice but to be all in love with his bae and stuff. Like, okay. I'm assuming that he couldn't get it on the phone call, or why he wanted to know, want the world to know that his boo, she driving crazy sometime, y'all. But she still his bae. She his wife. And he love her so much. You ain't, hey. Oh, wow. When he did get his phone call, he needed everybody to know this. Oh, this did tickle me to death. Oh, good grief. I thought he was sitting out like, I didn't know what kind of letter he had in the back of him when you was telling me about it, Lynn. But this, he professing his love. He say he gonna let the world know he love his bae. She may driving crazy. I don't know why he got to put that. He said, drive me crazy. I'm assuming this is sometimes. So wherever you at, I think it's Marshana Williams. You drive him crazy sometimes, but he said you still his bae, his wife, and I heart her so much. Because he drew the little heart. Oh, that's what he over there doing. You better be working on your damn case, boy. You better be taking down some notes about this damn case and how you gonna get off doing some damn hearts and some letters. That's what you better be over there writing notes about, over there writing love letters. You can write her when you get in your back in your personal quarters. But right now, you need to be writing notes to understand how you gonna get yourself out of this damn jam so you can get home to your bae, your wife, and showing everybody how much you love her. Because I tell you, if you go away and you get these football numbers, I don't care how many damn letters you put up here or how many times you profess to the world, she is going to be out, in my opinion. Shit, he need to be writing some damn notes. He's sitting up there writing love letters to post out. He confess his thing.
Photographs or any kind of references.
Right. And the defendants are shackled, but not obviously to the jury.
Yes, Your Honor.
And So I guess the motion is that paragraph B technically is granted with the understanding that there's an administrative order that deals with the media. Family
Yes.
members can be present. They just can't wear anything that might be considered inflammatory or sending a message to the jury. And uniformed officers obviously can be present in the courtroom you have to have security, and the defendant shall be restrained, but not so that the jury can see.
Yes, Your Honor.
So it's granted to that extent.
And then as it relates to paragraph C, names and addresses of potential juror summoned to try the case, I heard the court in addressing this motion previously. I guess we obtain or are provided the names and the addresses, I think, the morning of.
Yep. So no questionnaire, and then you'll get the names the morning of. So deny the motion as to a questionnaire, grant it as to the names and addresses, and again, that will be provided the morning of jury selection.
And then D, individualized and sequestered voir dire. I also heard, Your Honor, as well. I have done it both ways. I feel as if it's more effective, at least to do the penalty phase portion of it individually, as opposed to like in sections of 10 or 15 or what have you. But
Yeah, I'm not doing individual, no, we're not doing that. So we're doing, as I said, small groups, anywhere 30 to 45. We're gonna see what's workable with the number of attorneys we have, but
understood.
it's not gonna be done individually. So as to paragraph D, that's denied.
And then E would be very similar to what the court has previously ordered with regards to objections. Obviously, there should be no speaking objections.
Right, that's granted.
And then F has to do with miscellaneous procedures, one of those being where the state wishes to identify.
Come on, cameraman. I'm about to do it again. He ready. He getting ready. He ready. He about to do it again. He said, come on, cameraman. Come on. Get this again.
A defendant for the quote record. I would ask that that be done at the bench as opposed to the court commenting that the record has reflected that so-and-so, whatever witness has identified the defendant. If that's
You don't want to
the
get
state's
caught.
requesting that be done at the bench.
Don't do it again, I guess.
I'm gonna deny that request, so the state can ask it just if the record reflects, and I will indicate if the record so reflects. Okay?
There's no longer the issue with the
Okay,
expert. Okay, so then the next one, if Your Honor may, motion to declare section 921.141B1, which is CCP, which I believe the state filed a response to. And I would just stand on my motion.
That was all CCP.
Yes.
You know what?
6-1, 6I. What I-
6I,
maybe I
yep.
said.
okay, that motion will be denied.
And then the next one would be motion to declare 921.101.6B unconstitutional as written at, and as applied, and that relates to the prior violent felony aggravator. I believe the state also filed a response.
Does this defendant have an actual prior?
I looked, I thought that it was in the,
Does he, or are you
In the
just alleging the
notice.
contemporaneous conviction?
Judge, I can't speak to whether he does or not. I know all the defendants were relying upon the previous convictions for violent felonies. I believe this is Mr. Murphy, Dagon Murphy.
yes. I think it said or. Almost positive.
You believe he does, counsel?
I believe that the notice said or.
Or, okay.
Yeah.
I believe that's the wording in the statute, so we utilize that wording.
Okay. Well, as to it being unconstitutional, I'll deny the motion, but
You
obviously
better
before
say-
we get into a penalty phase, if the state is
just
gonna
didn't
rely
give
upon a
me
prior
There you
violent
go.
felony conviction,
Let me give a
make sure
paper
you've
together.
given them the defense.
He said, if y'all didn't get it the first time,
To
there you
let
go.
them know before the start of trial, okay?
We got you. We
And-
seen it.
Then the next one will be motion to declare 921.141.8 unconstitutional and for a pretrial determination on the admissibility of all victim impact evidence.
Okay. So as to it being unconstitutional, I'll deny the motion. but I will grant it with regards to a pretrial determination of admissibility.
Yes. And as long, obviously, that we receive those letters
Yes.
in advance. That
Yeah.
should-
Same ruling, at least 24 hours before anyone should offer the victim impact evidence in court before the jury. Has to be disclosed.
And then I would also adopt, I did not file, although I did tell Mr. Harmon that I was going to be adopting the motions that have been filed on behalf of the other defendants regarding the constitutionality of the new death penalty scheme applying to Mr. Murphy, not based on ex facto or anything of that nature, but based upon just general 8th and 14th Amendment rights. So I would adopt all of those motions and incorporate those
Okay.
in his argument.
Same ruling, be denied.
Okay, and then finally, we have motion to strike the aggravating factor. I think is that what you started with?
I have, yep, defendant's motion to strike aggravating factor, Florida statute section 921.1416N, which is the criminal gang member aggravator. You relying upon your motion?
I'm relying upon my motion. Yes, Judge. Yes, I am.
State, you relying upon your response?
Yes, sir.
Okay, the motion will be denied as to the unconstitutionality of that aggravator. All right, Ms. Toomey, any other penalty phase motions?
The only other thing that I might add for the record with regard to this specific aggravating factor, specifically for criminal gang members or associates, that has already been enhanced, I guess, if you will, in the indictment. So it's almost like a doubling up of that sort of kind of enhancement. So I would just make a general constitutional argument against the doubling up.
Same ruling, be denied.
I think that's it.
I believe so.
Yes.
The list I have.
Okay.
Your Honor, if I could readdress my motion to compel, so I can kind of let the court know where we're at as far as documents and records. Ms. Toomey has provided me with voluminous records, and I appreciate that. All types
Of what kind of records?
School records, I believe DCF records, other records, medical records possibly, in relation, Social Security records dealing with Mr. Davion Murphy.
Yes.
I know, Mr. Petridis, have you listed more than one expert? Is it multiple?
Yes.
I thought you had, okay. So I haven't received any records from any other penalty counsel. And it's my understanding if there is any that will be provided, I just want to bring it to the court's attention.
I've reached out to my experts. I don't have anything to say, but I told them to check if we're going to have anything else. I'll send it to Mr. Harmon.
Okay,
That jogged my memory, Your Honor. We have a small number of school records, Mr. Gafford. I did a notice of intent to rely, but now I think about it, I don't think I actually sent the records to the state, so I'll do that today.
okay,
It's a very 10-page.
okay,
And then I think that's it that we have for records.
okay. And have you received any records from Mr. Hernandez for Rashad Murphy?
I have not, Your Honor.
Judge, I'm going to text Mr. Hernandez now, and I'm going to also make a note to speak with him after the proceedings.
Okay.
And judges, is there a deadline on those records?
Well, yes, the deadline is come and
Rapino,
gone.
I heard the court say Rapino.
Pursuant to my scheduling order, those dates have come and gone. But anywho, I tell you what, let's do this. We're reconvening Friday, correct?
We are, Judge.
So I want you all to just make sure you check to make sure you have disclosed or are disclosing any records that you're going to rely upon in penalty phase. And then let me know Friday what your status is. And then if they've not been produced, then I'll give you an absolute, like, I'm not kidding deadline. I know my scheduling order should have been an absolute, I'm not kidding deadline, but things happen. So, okay. And Miss Toomey, I know you were busy, but have you heard back from your neurologist by any chance?
I emailed him.
Okay, that's fine. So we're reconvening Friday. So I just need to know by Friday when he's going to be able to get his evaluation done so that you can determine whether or not you're going to list him.
And that's exactly what I said, but I have not read.
Okay, that's fine. That's fine. Okay. Okay. Anything else we can get done today? Any suggestions?
Judge, I did have a motion in limine to all defense attorneys to requesting that they provide us with any sort of drill rap videos that they intended to use to list them and provide them in discovery. I don't think we addressed that.
Judge, if the court will allow, I have a brief response on that.
Sure.
Somewhere.
if I may, while we're waiting.
Sure.
I did file a motion. I'm assuming that this is probably gonna be put on Friday with all the other gang stuff.
Yeah, unless it's something we can get done today, relatively simply. No? Okay.
Not because of me.
No, I'm not, it's okay.
Judge, if they would prefer it be heard with the other gang motions, that's fine. I just thought that was something, because I was just asking that it be provided in discovery and listed.
Right, that's what she's asking at this point, not the admissibility, but just that if you've got any other drill rap videos other than what the state is intending, and if you disclose to the defense the ones you actually intend to admit at trial.
Judge, we will. I know we've listed probably more than we intend to use, but we will specifically list the ones that we intend to use.
Okay, yeah, by the time we reconvene Friday, you need to specifically identify the drill rap videos that you want to show the jury. And then if there are any drill rap videos that the defendants wish to show to the jury, they need to be identified and given to the state by Friday.
And Judge, certainly, the evidence view, we on Friday are going to talk about getting together. It'll be, as the court can imagine, monstrous.
Yes.
There may be some non-testimonial issues that come out of that evidence view that may be need to be addressed by the court.
Sure.
But we can advise you of that. My only additional concern in this state's motion in limine is that it doesn't limit itself just to videos. It suggests that the defendants refrain from making any direct or indirect mention or introducing into evidence any non-disclosed evidence of the victim's prior gang activity or videos. And I would object, and I don't think it's appropriate to suggest at this stage of the game that we should not be allowed to either question or seek admission of evidence or mention or have argument to what is described as the victim's prior gang activity. Now, granted, the court hasn't ruled on any of these things
Right.
yet, and I don't want to predispose or predetermine what that may or may not be. I agree wholeheartedly that we should be providing the state any rap videos we intend. But as it relates to argument or mention or questioning, I don't think that we can blanketly, as the motion is written, at least Rashad Murphy, agree to that.
Okay, and I'm not ruling on that motion yet. The sole issue that I hear Ms. Doherty raising is she just wants to know if there are any other in the universe of drill rap videos. Are there any other drill rap videos that any of the defendants are going to attempt to introduce at trial?
Understood, Judge.
Guilt phase. So you just need to tell her by Friday if there are. So once I've ruled on the other gang evidence and whether what's coming in or isn't coming in, then once I determine that, then we can start working on the motions in limine. So we'll kick off with the motion for me to determine how much of the gang evidence is going to come in, and then we'll go from there as to the remaining motions.
Judge, there is one mention I would make. I've been working on, when I can, and because of the late nature of the deposition of state witness Robert Howard,
Sure.
I've been working on what will be a non-testimonial motion in limine as to certain portions of what I anticipate Mr. Howard's testimony will be. And I just wanted to make everybody aware. I had spoken to the state some time ago. We just did get back last week the expedited transcript of Mr. Howard's deposition, although there was a previous proffer that we've been able to rely a little bit on. So I anticipate filing that motion as well, Judge, without significant argument other than those portions that we would seek in limine.
Okay.
And,
All right.
and Judge, I just wanted to comment on my motion limiting, because I did include gang activity. Obviously, I know that the court has not made any rulings about what will be coming in, but the state's concern obviously is bad character on part of the victim being inappropriately admissible by defense and last minute without us having the opportunity to fully vet and make any sort of arguments. So it does include not just the drill rap videos, but any gang activity that they're aware of that they intend to get into that's not been previously disclosed.
Okay. Okay. We'll start with the drill rap videos, and I don't know what that other evidence might be. I'm not really sure. So anyway, we'll see where we are on Friday. Okay, anything else for today?
Mr. Gabbard had a couple of other motions that fit in the category.
Sure. Just tell me what they are.
One of them maybe we should have done last week, but he has a motion to sever count 6.
Yes.
I think we laid out our position in our memo, and I know the state off response.
I
Our
did.
position is it's a separate transaction. I know that the state position is it's a causal link. But we believe it's sufficiently separated that the jury should consider count 6 separately.
Okay, and remind me, what is count 6?
Judge, that's the tampering with physical evidence that is when Mr. Gafford goes back to his grandmother's house after the offense on the same day and wipes down the car and removes the car from Tampa and leaves it in Auburndale.
Okay, sorry.
And Judge, we did file a written response to that, again, saying that that is properly joined and requesting that it not be severed, as it specifically is connected and joined in an episodic manner, which I think is the case law, which says that that is properly joined.
Okay. Any response, Mr. Wise?
Only, Your Honor, it's a separate incident that's allegedly taking place. It's happening in Cook County. It doesn't involve anyone else in the room. I recognize the state's position, but it's separating time, separating space. It's two separate acts. It should be tried separately.
I'm going to deny the motion to sever count 6. Okay. Anything else?
We had filed a motion to compel the location of all license plate readers along this path. That's
Right.
We have hits from, we know where license plate readers hit. I don't know, and I know the state mission discovery, and maybe we missed it. I don't think we have locations of any license plate readers that didn't hit. I know I addressed this in other, at least one of the cases, and I think there are some law enforcement concerns about disclosing it, but I think it's relevant if we're seeing evidence of where it hit. There could be license plate readers along these alleged paths that didn't hit. I think that's.
So you want the state to give you the universe of license plate readers along a
Yes.
travel?
Between here, Orlando, Jacksonville, yeah, along these routes of travel, which I know there's more travel in this case than a lot of cases where, we're talking about just someone traveling to Tampa. But I think it is relevant reading.
Huh, I don't know that's Brady. Okay, state, what's your response?
Judge, we have complied and given them all of the license plate readers where they hit. Judge, we don't know the specific path of travel, and I did specifically talk to the detective. If it is not captured on a license plate reader, it's not something that we can use in the particular case. It's a matter of timing and how the car passes. Some of these license plate readers are mobile. And so, Judge, there's no way for us to know. And there are different companies for different license plate readers. There just isn't any kind of, it's not exculpatory by any means. And without knowing the specific type of travel, when they got on, when they got off, if they took a break, there's just no way for us to be able to provide that.
But you have provided for the license plate readers that are going to come into evidence, the location of those has been disclosed.
Yes, they are disclosed by address, Judge.
Okay. All right. So I'm going to deny the motion as to any license plate readers that were not triggered during the course of travel of the defendants. Okay. I don't find that it's Brady. Okay. Anything else?
Yes, Judge, there were just, I think there was a couple additional matters. You asked us with regards to that Richardson case that occurred in Jacksonville.
Right.
What was the reason that there were 2 juries and that was a proven issue.
Okay.
And I believe Ms. Ismore has a copy of the actual order that lays that out if you want us to forward a copy to you as well as defense
That's
counsel.
fine. I take you at your word that it was a brutal problem. I just was curious.
And then I did want to know if the court wanted to do a formal colloquy on the record. I know that Mr. Petratus had to step out for a moment. I think it was the last time we met for motions for a
Yes.
small period of time. We did go ahead and order the transcripts for what happened during that time period. If Mr. Petratus wanted to take a look at that or had any sort of additional argument to make, I know that there was additional counsel that was tasked with kind of asking questions, or was tasked with asking questions during that time period on his behalf.
Yeah. And I just want to thank you for reminding me about that. So I think the last 2 witnesses, and I think it was Drayback and was it Trey McCullough?
Yes,
the last
those were
2?
the last 2 witnesses.
And I'm sure you were advised of this, Mr. Petratus, but Detective McCullough had no information related to your client at all. And then Detective Drayback, and this was done as a proffer to establish these detectives as gang experts.
Yes, Your Honor.
Okay, and I don't see Detective Drayback being declared an expert in this case, just because the gangs that he is tasked with, and I don't have my notes right in front of me, but there's a different gang or set of gangs in Jacksonville that he's focused on.
Yes, Judge, I believe we just listed him because he's not involved in a specific gang, but was the liaison and handled most of the matters as a general gang expert for Jacksonville gang activity.
Yeah, but you've got 3 other people to choose from,
Yes, Your Honor.
right?
Yes.
So at this point, it'd be cumulative anyway. So yeah, here are my notes actually. His gang of interest is the 21st Street gang. And he testified he doesn't have any specific familiarity with 6 Block. And he's assisted other members of the gang unit with regards to ATK and 1200. But the 21st Street gang is his specific one that he focuses in on. So Detective Drayback is not going to be testifying as a gang expert against Mr. Chance or against any of the defendants in this particular case for that reason. The state's got 3 other people to choose from, and Detective Dravak's gang is not a gang at issue in this trial, okay? So I did indicate that the state's ordered a copy of the transcript, and if for some reason you wish to ask any further questions of either Detective Dravak or Detective Trey McCullough, then we'll set up a Zoom hearing. So,
Judge, Mrs. Rose kind of provided me with a copy of it, and we'll write no further questions. So that's the questions I want to ask, I think. And
Yeah.
I was present for the depositions of those witnesses in Jacksonville, so I anticipated
Right.
that would be the outcome.